I want to speak about authority to arrest. The criminal code empowers two classes of persons to perform an arrest without warrant. Those two classes of persons are defined by Section 495 of the Criminal Code, which applies to a peace officer, and 494 of the Criminal Code, which applies to a citizen. So Section 494 of the Criminal Code entails the authority for a citizen to make an arrest, or that reference known as a citizen's arrest, and 495 speaks about a peace officer making an arrest, and the heading of both sections in the Criminal Code specifies arrest without warrant. Arrest without warrant. A peace officer has slightly broader authorities to arrest somebody without a warrant than does a security guard or an ordinary individual, and I'll speak a little bit about that distinction in a second. I want to speak to you about the fact that the only time a citizen is ever given an authority to arrest is in a situation where that individual, in this case a security guard or any other citizen, has personally witnessed an offense occur. That's one of the important distinctions between the authority given to a peace officer in Section 495 and that given to a citizen. And a security guard has the same level of authority that any other citizen might have, the authority given to a citizen to make an arrest without warrant. The principal difference that I want to focus on in our section has to do with suspicion. A peace officer, and you need to remember that every police officer is a peace officer. The term or designation peace officer is slightly broader than just police officer, but every police officer is a peace officer. A peace officer is given authorities to arrest someone on the basis of suspicion. Imagine that a citizen approaches a police officer and says, hey, that guy over there, I just saw him do this and that and the other, and these are serious accusations. A peace officer is empowered to arrest the individual on the basis of suspicion that the individual has committed a criminal offense. When it comes to a citizen's arrest, which is contained in Section 494 of the Criminal Code, no such right exists, in the sense that a citizen, a security guard, is permitted to make an apprehension only under conditions where he or she has personally and independently witnessed a serious criminal offense take place. So that's the first thing that I want you to understand. The authority to arrest, a citizen's authority to arrest, is very restricted and very restrictive. One can only make an apprehension when an individual has independently witnessed a serious criminal offense occur. A security guard, a citizen, is not permitted to arrest anyone on the basis of second-hand information. So if somebody approaches me, and it doesn't matter who that somebody is, and says, hey, I just saw that individual do this and that and the other, go arrest him, there is absolutely no authority on my part. I have absolutely no right to make an apprehension because I did not personally witness the criminal offense take place. It's very important for you to remember that you must personally and independently witness the commission of a serious offense. So A, you have to be sure that you witnessed the offense take place. B, you have to be certain that it's an offense that requires, that allows you to perform an arrest. And those are essential elements, aspects of making making an apprehension that I want you to remember and to understand. Section 494 of the Criminal Code deals with a citizen's authority to arrest, and I want to sort of discuss with you the issues, the specific issues pertaining to 494 and making a citizen's arrest, and I want to dissect some of the important sections with you. The section begins as follows, 494 sub 1. Anyone may arrest without warrant. And there's an awful lot of information that's conveyed within that portion of the sentence. Anyone may arrest without warrant. So let me dissect those elements or aspects of the sentence here. Anyone clearly means a citizen, because the criminal code in all other aspects or areas where it intends to or it refers to a police officer or a peace officer says exactly that, a peace officer or a police officer. So reference to anyone in this context clearly means a non-police officer, which is a citizen. So anyone means a citizen. May arrest. Anyone may arrest. The reference may arrest is different from must arrest. The section of the Criminal Code having to do with citizens' arrest doesn't compel a citizen to make an arrest. In fact, it doesn't even recommend that citizens engage in any sort of vigilante justice. Citizens are not encouraged to make arrests. They're encouraged to call police when they witness a serious crime take place. It just happens that a security guard is responsible for property owned by his or her client, and therefore may be in a position where they're required as part of protecting that property to perform an arrest. So anyone may arrest, as I said, not must arrest, a person whom without warrant. Anyone may arrest without warrant. The reference without warrant means found in the commission of an offense. Arrest without warrant is arresting somebody who has been witnessed committing a criminal offense. Otherwise, if somebody had committed an offense in the past, and we have an opportunity at some point in the future to identify that individual, this is something that should be reported to police, and a police officer has an opportunity, has time and an opportunity to obtain a warrant in order to arrest that individual. But an arrest without warrant implies arrest at the time that an offense is actually being committed. So anyone may arrest without warrant means caught in the act, catching somebody in the act. And then the section proceeds to explain the conditions under which anyone may arrest without warrant. So sub 1A reads as follows. Anyone may arrest without warrant A person whom he finds committing an indictable offense. And it continues with B, or a person who on reasonable grounds he believes has committed a criminal offense, and 2, is escaping from and freshly pursued by persons who have lawful authority to arrest that person. So really, for the purpose of our discussion, we're really just concerned with 494 sub 1A, anyone may arrest without warrant, someone whom he finds committing an indictable offense. The other section, sub B, discusses an offender who may be fleeing custody of police. A police officer says, hey, who's chasing an individual, says, hey, grab that person or assist in the arrest. That's a different issue. In 494 1A, we're talking about a citizen having personally witnessed the commission of an indictable offense. 494 continues with subsection 2, and now the subsection discusses the owner of property. So 494.1 speaks about anyone may arrest without warrant, and 494.2 speaks about a property owner. So let's take a look at the wording of 494 sub 2. The owner or a person in lawful possession of property, or a person authorized by the owner or by a person in lawful possession of property, may arrest a person without a warrant if they find them committing a criminal offense on or in relation to that property. And I will come back to discuss the and. It speaks about the point at which the apprehension is being made. But I want to pose a challenge, a question to you before we move further. And the question has to do with seeing if you can understand the difference between the wording in subsection 1 as opposed to subsection 2 of the criminal code. Now, you'll hear us often say that at the core, the study of law really is the study of language. So we have to take a look at the language within the criminal code to understand the difference between sub 1 and sub 2. Subsection 1 says anyone may arrest without warrant, A, someone whom he finds committing an indictable offense. And subsection 2 says the owner of property or someone in lawful possession of property. Why is subsection 2 included? And subsection 2 says the owner of property. If subsection 1 says anyone, is the owner of property not included in that broad category of anyone? So again, to be clear on the question, subsection 1 of 494 says, anyone may arrest without warrant a person whom he finds committing an indictable offense. And sub 2 says the owner, or a person in lawful possession of property, or a person authorized by the owner by a person in lawful possession of property, may arrest a person without a warrant if they find them committing a criminal offense on or in relation to that property. And so the question again is, what is the difference between sub 1 and sub 2 of the criminal code? And the answer is evident when we dissect the difference in language between sub 1 and sub 2. If you look again, section 494 subsection 1 says anyone may arrest a person whom he finds committing an indictable offense. What is an indictable offense? According to the classification within the classifications within the criminal code, an indictable offense is deemed to be a more serious criminal offense. So anyone may arrest without warrant someone whom he finds committing an indictable offense. If you look at subsection 2, what it specifies is that the owner of property or someone in lawful possession of property, someone authorized by the owner, that would include a security guard who has been hired in order to help protect property, may arrest without warrant a person whom he finds committing a criminal offense on or in relation to that property. So a property owner is given added authorities to arrest a person who commits a criminal offense, not necessarily simply an indictable offense, a criminal offense, even a less serious criminal offense, which would be defined as a summary offense in the criminal code, if that offense is occurring on or in relation to the individual's property. So whereas every citizen is given a broad authority to arrest someone whom he finds committing an indictable offense, the owner of property, and of course a security guard acting on behalf of the owner, is empowered to arrest someone even if that individual is committing a less serious criminal offense. For example, trespass at night, or an offense of a mischief in relation to property. 494 continues with a reference to when the arrest can or should take place. And it speaks as follows. We read section 494 sub 2, and I left off with the word and. A, they make the arrest at that time, at the time that they witness the commission of a criminal offense, or B, they make the arrest within a reasonable time after the offense is committed, and they believe on reasonable grounds that it is not feasible in the circumstances for a peace officer to make the arrest. Then subsection 3 is very important for a security guard to take note of. It reads as follows: anyone other than a peace officer who arrests a person without warrant shall forthwith deliver the person to a peace officer. So a security guard who makes an apprehension, in fact, any citizen, any non-police officer or non-peace officer who makes an arrest has a legal obligation under the criminal code to forthwith deliver that person into the custody of a police officer. So what you cannot do is make an apprehension and decide that you're going to hold on to the criminal for a time so that you can discuss with him the errors of his ways. That is not permissible under the law. You have an obligation to contact police and turn the thief, the criminal, over to the custody of police. Subsection 4 of 494 continues with, for sub 4, for greater certainty, a person who is authorized to make an arrest under this section is a person who is authorized by law to do so for the purposes of section 25, and we'll discuss section 25 another time. So to recap our discussion, we have spoken about the following. Section 322 of the Criminal Code discusses the offense of theft. It speaks to you about what theft is, and more importantly, it speaks to you about when theft occurs. We said that it's difficult, it could be difficult to really apply Section 322 in a retail environment by virtue of the fact that in a retail environment, a store invites people to come in and try things on and move things around and so on. So if we looked at the strict application of 322 sub 2, somebody commits an offense, the offense of theft, when they cause something to become movable. That doesn't quite work in a retail environment. So whereas ordinarily the criminal offense is made up of actus reus and mens rea, in a retail environment we convert those two elements into the three elements of selection, concealment, and evasion of payment. Only after we've clearly witnessed all three elements, and particularly evasion of payment, can we make an apprehension. The Criminal Code empowers a citizen. A security guard has the same authority to arrest as any other citizen, empowers a citizen to make an apprehension. The conditions under which a citizen can arrest include the following. A, anyone may arrest without warrant someone whom he finds committing an indictable offense. So it's a serious criminal offense for an ordinary citizen or for the owner of property if the offense, even if it's not necessarily a particularly serious criminal offense, if the offense is occurring on or in relation to the owner's property, then the property owner or a security guard acting on behalf of the property owner, somebody authorized by the owner, is permitted to make an arrest without warrant under those conditions. We said anyone other than a police officer who makes an arrest without warrant must deliver that individual, the arrested person, to the custody of a police officer. In our next session, our next video, we'll discuss, in another video, we'll discuss the procedure of making an apprehension, and we'll discuss the Charter of Rights as it relates to an apprehension. Please don't think that it's a simple or an easy thing. It's not a casual thing. It's very important to understand that you can't just make an arrest of an individual. There is no right that people in Canada have that's greater, that's more important than the right to walk around freely as they choose and go where they want. So we'll speak about conditions that pertain to issues surrounding surrounding an arrest in another section.